May I please, Lordship?
Yes, please.
My Lord, I beg to mention item number 7. My Lord, here I've received instruction, so kindly allow me 2 weeks time to file affidavit.
Mr. E. Tibaka.
May I please, Your Lordship, here in the same case, extension order have been passed, detaining the.
So your
continue for
petition is
another 2 weeks.
infructuous? Your petition has become infructuous if in the meantime extension order has been passed. You have to file a fresh writ petition.
Yes, my lord, I may be given the liberty to file.
Mr. So-and-so, learned counsel for the petitioner, submits that he has instructions to withdraw the petition with liberty to file afresh. Where is allowed? Petitioner is allowed to withdraw the writ petition with liberty to file afresh.
Much of that.
May I please, Your Lordship?
Yes, Ms.
I'd
Apina.
like to mention item number 12, 13, and 14, part 2, Lordship. Giving on behalf of the NIA, Lordship,
Yes.
let the matter come up after 6 weeks, Lordship.
6 weeks.
Lordship,
Well,
Lordship, some arrangements are going on for.
you are the counsel for the NIA.
Officially not engaged, Lordship.
You are mentioning on behalf of
Mentioning
NIA, on
NIA.
behalf of some lawyers.
And then Mishra, Lordship. New engagement is already on the process, already completed. The matter will come up after 6
MS Apila Sankam makes a mention on behalf of Mr. N. Mishra, the learned counsel, NIA, and seeks adjournment of the case for 4 weeks.
Lordship.
Prayer is allowed, listed accordingly.
Lordship.
My lord. My lord, I'm appearing for sole respondent in item number 14. What to say?
Okay, Mr. So-and-so, learned counsel, appears for the respondent, sole respondent
Yes, my lord.
in CRAP 5/2022. Okay,
Obliged, Lordship.
yes.
Your Lordships, I'd like to mention item number 5 on behalf of Senior Government Advocate Mohan Chen. As is indisposed, we that the matter may be listed after 2 weeks.
Mr. So-and-so, the learned government advocate makes a mention on behalf of Mr. Mohanchan, the learned senior government advocate, and seeks adjournment of the case for 3 weeks on the ground that the learned senior government advocate is indisposed. Prayer is allowed, listed after 3 weeks.
Your Lordship, also item 16 on behalf of Mohan Chen. The matter may be listed after
Same order, item 16.
after 1 week next on state Lordship. On 10th.
After 2 weeks, after 2 weeks.
Right.
Your Lordship, Your Lordship, I beg to mention item number 4. Your Lordship, we are yet to receive an instruction from the Ministry of Filing or Affidavit.
You are for?
Yeah, for my senior Gauhati CTC, Your Lordship.
Okay. Okay. MS V. Sokri, the learned additional government, the learned additional advocate general, and Mr. So-and-so on behalf of Mr. Yangarwati, learned CGC, 6 for 3 weeks time.
4 weeks, Your Lordship.
6 for 4 weeks time to file their respective affidavit. Prayer is respective affidavit. Prayer is allowed, listed accordingly. Okay.
So, Chief,
Yes, ma'am.
don't you like to mention admission item number 2? Chief, we may be granted 2 weeks time to file our affidavit since the mission director has been promoted and the new mission director has not been appointed yet, Chief.
You are mentioning on behalf of
Mr. Anmozo, Chief.
MS so-and-so, learned counsel, makes a mention on behalf of Mr. Ann Moser, the learned counsel for the respondent number 3, and seeks adjournment of the case for 3 weeks on the ground that
The new mission director is not appointed as
on
the
the
mission
on the
director
ground
is
that the
appointed.
new mission director is yet to be appointed.
Yes, Chief.
Where is allowed, listed accordingly.
Yes, Chief.
Yes, ma'am.
I may be allowed to make a mention on hearing item number 15 on behalf of my learned senior, Mr. Joshua Shafiq. Your Lordship, kindly refix this matter after a week, considering
Okay,
the fact that my senior is out of station.
Ms. So-and-so, learned counsel, makes a mention on behalf of Mr. Joshua Shakti, the learned counsel for the petitioner, and seeks adjournment of the case after 2 weeks. Prayer is allowed, listed accordingly. Yes. You are the counsel for the petitioner, Mr. So-and-so, learned counsel for the petitioner, seeks adjournment of the case for some time. Prayer is allowed, listed after 2 weeks. Okay.
May it please your Lordship,
Yes,
I'd like to mention item 11.
yes,
Here, my lord, the honorable court have allowed me to file additional affidavit,
yes.
for which I'll be filing in the course of the day.
You are,
Additional affidavit.
you are the counsel for the,
Respondent number 1.
or what? Okay.
I serve the copy to the appellant also.
Mr. So-and-so, then a counsel for the petitioner, respondent number 1 submits that he will be filing the additional affidavit in the course of the day, and therefore seeks adjournment of the case after 2 weeks. Prayer is allowed, listed accordingly. Okay,
Hello, Pak.
yes.
For motion, item number 1.
Yeah, please, your lordship.
Yes,
Lordship, this appeal is directed against the Indian order dated 1/3/2024 passed in the PBC 1/26 of 2023. Lordship, the issue was rejected on three counts.
your claim for retrospective or regularization.
My lord,
We are issuing notice. We are issuing notice.
Lordship, my lord, I am praying for interim order.
No interim.
My lord, only on the MACP.
No, no, no.
My lord, the issue is this. I was directed.
When actually your appeal has no interim prayer for
No, my lord,
staying suspension of the appeal.
IA, my lord,
No, 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 no.
I filed an IA.
No,
Because
no, no.
the issue is this, Lordship. Lordship, we can't get
That
out
has
of
not
the
been
class.
allowed in the main appeal, in the main writ petition. That has not been allowed. Mr. Taka, I think we'll issue notice on your this interim also. We'll issue notice. Heard Mr. Takamasa, the learned senior counsel, assisted by Mr. So-and-so, learned counsel for the appeals. The present appeal has been filed challenging the judgment and order dated 1/3/2024 passed by the learned single judge in WPC 123/2023. Stop. Issue notice to the respondents returnable after 4 weeks. MS Mary, you are appearing?
Yes, Your Lordship.
Since MS Mary, the learned senior government advocate, appears on behalf of all the respondents,
Yes,
no formal notice need be issued to the state respondents. The learned counsel for the appellant shall however take steps for furnishing requisite copies of the appeal petition to the learned government advocate in the course of the day. Okay. The IA. Mr. Takamasa, learned senior counsel, assisted by Mr. So-and-so, learned counsel for the applicants. The present IA has been filed. seeking for an interim order to stay/suspend the operation of the letter dated 18/9/2023 issued by the Director, School Education, and also to direct the respondent not to initiate any steps for recovery of the MSCP, ACPs of the applicant with effect from 16/1/2014 till the disposal of the writ petition, of the appeal petition. Stop. Issue notice to the opposite party respondents, returnable after 4 weeks. MS Mary, the learned government advocate, appears for all the opposite parties/respondents. Therefore, no formal notice may be issued to the said respondents. The learned counsel for the applicant shall however serve the requisite copies of the application to the learned senior government advocate in the course of the day. Okay.
But they can fix a date.
After 4 weeks, first time, after 4 weeks.
My lord, my submission, my lord, if the IA can be heard little earlier than 4 weeks.
No,
that's
no,
not
no,
interim,
no, no.
lordship. Because lordship, if my petition succeeds, then automatically the recovery also will be recovered. But in the meantime, my lord,
your prayer has not been granted in the writ petition, we cannot actually grant you.
lordship,
that interim.
the issue was this.
No, Mr. Takamasa, you know very well, you're conversant. So please don't ask for that date. Please.
For admission, item number 6.
Yes, Mr. Lima.
Please further state.
The applicant shall take steps within 2 days for service of notice on the by routing through the registry of the court, and upon service an affidavit shall be filed. Have you filed the affidavit?
The IE, we are going for contribution of 569 days.
Sir,
The
where
IE
also-
itself is not meeting.
Pardon?
The IE, we are going for contribution of 569 days. The
Who-
IE itself is not meeting. The state.
The state.
The IE is filed under room for it. Instead of filing the IE under section 5 of the Limitation Act, we are filed under rule 2, clause 2 of the chapter 5E. Chapter 5E of rule 2E only prescribe for filing an appeal, not for contribution.
Let's see the book. What the High Court rules? If that be so, I think you will have to withdraw.
The second sentence, I think cover my case.
Huh.
Says the division bench may condone the delay in filing any appeal
Huh.
if good and sufficient cause is shown.
But will that not have to be read with section 5 of the Limitation Act? That is the main, I think, a provision, section 5.
Here he says in this worksheet. From technical ground in other matter other than can you allow to amend this the post title? Since I've already filed my affidavit, the contents of the
Your objection is not under section 5. Where is the law that limitation act is applicable in case of writ petition and writ appeal? Where is appeal applicable? Limitation act is applicable made in appeals and proceeding which are given in schedule. So as where is the writ appeal?
Yes, Lordship, in the schedule itself.
Where is the writ appeal? In the schedule, where is writ appeal under section 5? And where is the period prescribed for preparing writ appeal?
Lordship, schedule 117 says that
Huh?
from a decree or order of any high court to the same court.
Huh?
So now you're selling an order passed by the under single judge before division bench.
No, when an appeal is provided, when it is a decree, it is an application under Article 226, is not it? Original application. When it is an application under Article 226, applicability of Civil Procedure Code or Limitation Act is ruled out. No period is prescribed for preferring a writ petition. Only court can reject on the ground of unreasonable delay and lessage. No time is prescribed. So same is the thing, there is no prescription of time. So therefore, the rule 2 of sub-rule 2 is prescribed. This is one. Otherwise, suppose section 5 is not mentioned, it will not be fatal. Will it be fatal? The sum and substance is that state has preferred an appeal. There was a delay. Now we'll have to decide whether that delay is cause or sufficient or not. That's
Yes,
all.
yes, without going into the limitation.
Where is the
That also can be
sufficient?
heard, no, grounds also can be heard.
Hmm?
Whether the applicant, whether they disclose the sufficient cause or not, Lordship, that also can be heard. Lordship, for a period of more than a year, there's no explanation in the IE. If you see the contents of the IE, for a period of more than a year, there's no explanation. It is your blank statement that you were consulting a government advocate.
Why don't we hear the appeal on merit, Mr. Lima?
Bishop, the IE may be discussed first.
That's why. Why don't you at least concede? To the IL, let us hear the matter on merit.
Bishop, the apex court has held that
Let us not be very technical.
when the deal is not properly and satisfactorily explained, and when the state is prescribed.
We impose cost. Because actually, if you say that the delay has not been properly explained, we impose cost on the state. We condone the delay. We don't want to be very technical. We want to be generous.
Only one citation I would like to cite, just one paragraph. Pass for the apex court.
There are 100 judgments you will get in this side. The sum and substance of all these judgments are that sufficient cause.
Sufficient.
Delay may be, period may be small, period may be larger. The whole sum and substance is whether sufficient.
Whether there is sufficient explanation or not.
So far relating to government, you will get 100 of cases where said court should be lenient so far relating to the government. You will get judgments where court says that no further. No further in government also will treat them equally. That postmaster general.
In this case, the apex court says that on equitable ground.
No, that's why my brother is saying,
Equitable grounds should not be.
if we have to actually see that there are 101 judgments in favor of the government.
Both sides. So no need to show judgment.
Roship, if you see the content of this,
What is the judgment? Postmaster general.
No, Roship. This is passed in the year 2014. Roship, in here it says.
You come prepared. We'll give you time. You come prepared. You come prepared.
If necessary.
You come with proper citations.
Lordship, I have one
You-
citation, 2023, last year. So.
You give an explanation, register postmaster general judgment.
2006.
2000?
6, I think.
That is where the everything is dealt in so far
Roship, in
relating
that case also you
to
see that.
appeal preferred by. Come with that.
Roship, because of the modern technology, the state should not slumber.
But again, here it says that impersonal machinery, then all these technical
Therefore, you come with that judgment. Everything is dealt in Postmaster General. Are you aware of that judgment? So you'll have to, moment you proceed, we'll have to answer the Postmaster General.
We want to be lenient, but you have to satisfy us. We want to be lenient. So far as this
Delay is concerned.
we want to be lenient, but you satisfy us with proper judgment.
I'll try to satisfy.
Yes, we list it after 2 weeks. You come. That Mr. So and so. That Mr. Kiangami. The learned senior government advocate for the applicants, and Mr. Lima Wabang, the learned counsel for the opposite party. Listed after 2 weeks. Come prepared. Let us hear.
For admission, item number 8.
Yes, Mr. Muli.
My lord, the respondent is not present.
Today you are taking advantage of that, eh? Well, if see, let us.
12-3 last declared. I know, collect number. Petitioner is not here.
Petition appellant is here.
Appellant is here, respondent.
Mr. Zatan Muli, the learned CGC, present for the appellant. Stop. None appears for the respondents. Listed after 3 weeks.
1 week, my lord.
Listed after 2 weeks. 2 weeks.
But please.
For hearing, item number 10.
Yes.
Lordship.
Mr. I think we will not take up hearing matters.
My lord, this is a long pending matter, your lordship.
The other is not keeping well.
Oh.
That's why.
Oh,
He's not keeping well, that's why.
So I will actively take up your case when I'm maybe after 2 weeks.
I did not do that.
Maybe after 2 weeks.
I am also your lordship having back kick. I cannot.
Then why you want to stand?
Lordship, as per your lordship's verbal order, parties were directed to furnish the gist of arguments, lordship, before this honorable court. So if I may be
So
permitted
no,
to submit.
we accepted the argument on the date of hearing.
I also prepared.
Okay.
You also prepared and come?
Yes, I also prepared.
Oh, you have also.
Yes, lordship. Since your lordship is not.
He's not keeping well. That's why.
Mr. V. Devnath appears for the appellant, and Mr. P.P. Paul appears for the respondent number 1 to 11. Listed again after 2 weeks.
Your lordship, on 19, I am going for treatment in Bangalore.
Okay.
Consensus date.
Okay, give a date then.
May, it will be May 1st week, because on 19 I am going out. Or
Listed again
on 19 April I am going out. May 8.
Listed again on
May 8.
listed again on 1st May.
Okay.
1st May
Okay.
20,
8 May, Your Lordship, by chance, if it takes, on 19 I'm going.
listed on 8 May 2024. As it is submitted that Mr. P.P. Ball, the learned counsel for the respondent, will be undergoing treatment for some time. Okay.
Mr. Paul,
Yes,
just one query.
yes.
These RFAs are still in division bench
Actually, Your Lordship, this is a matter of single
Single
bench.
bench.
Your Lordship.
because as per subsequent notification and High Court
Yes,
rules,
Your Lordship.
all first appeal is before the
Single
single
bench.
bench.
Single bench, Your Lordship.
How it came up here?
So
I
this
see.
is very bad.
Huh?
Since the institution of the appeal lordship, it is before.
Pardon?
Since the institution of the appeal lordship,
2011.
2011, it is before the
principal
honorable division bench lordship.
Ha.
Since the institution of the appeal lordship, it is before the division bench. It is coming before the division. 11.
Then Your Lordship,
No, there is some value, it dependent upon the value. Up to a certain limit, it was single bench, and up to thereafter, it was higher in division bench. Subsequently, it was amended, and all certain matters which were earlier in single bench, these all were returned back to the district judge.
Okay,
Appeal. And then thereafter, what happened? All other matters above certain value, it is under single bench. So we'll ask the registry to verify. If we
all
saw
the matters are similarly situated that been taken in.
Registry to ascertain as to whether the present RFA will be filed before the division bench or before the learned single judge. Okay.
Much of.
Much.